Um, I'm Brooke Detterman. I'm the president of the Legal Sustainability Network's board. I'm also a partner at Beveridge and Diamond, an environmental law firm, and I focus largely on ESG and climate and renewables these days. Joining us today is my colleague Claire Schachter, who's going to do a presentation. Before I introduce her, I'll just give a couple quick updates on the LSN front. We've launched a carbon calculator this year, which is accessible and free to all members. We've been having webinars every month, sometimes 2 a month, and we are launching quarterly member forums. We did our first one a few weeks ago and had good feedback on that. So we're going to keep doing that, which will be more of an informal virtual gathering of various members to talk about different topics. So more on that soon. We'll probably take a pause from programming over the summer somewhat, since I know people have hectic schedules and summer associates and things like that sometimes to manage. So without too much delay, joining us is my colleague Claire, and Claire is one of our expert sustainability lawyers at Beveridge and Diamond. She joined us last year. She's one of our of counsel in our DC office. Last year, right, Claire?
That's right.
Feels like you've been here forever. Okay. She was working at a big firm before that. And she works on a really interesting range of stuff. So she's worked with me on some green lending and financing stuff under the Inflation Reduction Act and deploying federal funds and some of the recent kerfluffle that's gone along with that. She does a lot of work on corporate strategy, disclosures, and compliance under US and EU regimes, largely related to sustainability and GHGs, as well as green marketing requirements, supply chain, modern slavery. I'm just running through my list here, like a whole list of compliance items that big companies need to be aware of that kind of intersect trade, environment, and sort of emerging national or international frameworks. So she is an expert, I would say, on greenhouse gas disclosures and how those might fit into the law firm world. I realize that not all of us have to report under these, but some law firms do. They're big enough, or they're in scope, or they're in Europe. And increasingly, we're also seeing client pressure to have this kind of data. So Claire, if I have botched anything in my intro, I apologize. Feel free to correct me, and I will hand it off to you now.
Thank you. You botched nothing. Appreciate the introduction and the opportunity to speak to you all today. As Brooke mentioned, I'm going to cover greenhouse gas disclosures. I'm going to start with developments in the US and then focus at the state level for various reasons, and then turn to international developments focused on the EU, and wrap up with some key takeaways and leave some time for Q&A. And if you do have questions, please feel free to put those in the chat. So to start off, GHG disclosures is a very broad topic. It can encompass requirements that are applicable to stationary and mobile emission sources and facilities, and also entity level requirements. I'm going to focus today on new greenhouse gas emission and climate related financial risk reporting requirements. So the yellow circle on the slide here. But I think it is helpful to briefly situate those new requirements in the context of the broader disclosure landscape. So in the US, we have longstanding federal and state greenhouse gas reporting programs. At the federal level, the key program is the EPA's Greenhouse Gas Reporting Program. And that program collects information on emissions from large industrial facilities and power plants. And it's been collecting information dating back to 2010. There are, I think, around 8,000 facilities and suppliers that report under that program and calculate their emissions and report annually. The Greenhouse Gas Reporting Program is part of the current Trump administration's broader deregulatory agenda. So EPA announced in March that's actually reconsidering the program. It delayed the reporting deadline and is reportedly planning to eliminate the branch that oversees the program. So that's something that we're tracking just at B&D. At the state level, there are states that rely on EPA's emissions inventory, and then also states that have independent statutory authority to collect emissions information. Again, these are focused on industrial facilities, really, fossil fuel producers, suppliers. The objective is to collect emissions information and allow governments to track changes over time, compare performance between facilities, and inform environmental policies. So some of those motivators are behind some of these new requirements, but the new requirements are really kind of come from with a different objective, which is to provide information to investors and consumers on the carbon footprint of companies and their climate-related financial risks. So it is going to provide information to governments that will be useful, from a policymaking perspective, but it's also going to provide the public with more information and comparable information relating to greenhouse gas emissions and climate risks. This is not new territory for a lot of larger companies, at least, which have been disclosing greenhouse gas emissions and sometimes their climate-related financial risks for a long time under voluntary reporting frameworks. But it is a new territory for a lot of smaller and mid-sized companies. So that's sort of the US landscape, and I'll talk a bit more about the international landscape in a bit. So before we dive into the details, I think just kind of thinking about what the implications are for law firms. First, as Brooke mentioned, it's possible, and it probably is the case, that some larger law firms are in scope of these new greenhouse gas emissions reporting requirements. The revenue thresholds are fairly high, but they may come down over time, depending on political environment. So it's possible that firms that aren't in scope now could be in scope in the future. But even if law firms aren't directly in scope, many your clients may be, or your clients' business partners. And so there will be indirect impacts. As I'm sure, and you're aware, there are increasing requests now for law firms to provide emissions-related information as part of RFPs or otherwise, as clients are thinking about their own carbon footprint, about their own Scope 3 emissions. And those requests are likely to continue and increase as some of this legislation continues to roll out. I'll talk a bit more later, but it's a particularly difficult time for clients and the firms that are in scope to kind of gauge how much energy to put into some of these compliance with some of these requirements, especially because they are likely to be targeted by the Trump administration. But there are jurisdictions that are moving ahead, notably California. So regardless of the uncertain political landscape, there are at least a few requirements that seem very likely to continue moving ahead. And the last thing I'll flag here in terms of impacts for firms is that as there are increasing requests from clients to disclose additional information regarding greenhouse gas emissions, additional pressure in the market to make public statements or claims about how green or sustainable a firm is, it's a good time to revisit the public claims that you're making about greenhouse gas emissions, your own carbon footprint, and keep an eye out for green marketing risks, because we are seeing kind of in parallel to these new disclosure requirements, new regulations targeting green claims, and specifically focused on making sure that companies are substantiating the claims they're making about their climate actions. So a little more background, kind of how did we get here to this this landscape of new mandatory requirements? That some companies have been reporting under voluntary frameworks for a long time. There are many of these frameworks. As you can see on the left column here, these sort of so-called alphabet soup of reporting frameworks with the Carbon Disclosure Project, the CBP, the GRI, the SASB standard, the Task Force on Climate-Related Financial Disclosures, TCFD. What these reflect really is the impact of the impacts of climate change have materialized. Investors and regulators have become more focused on ensuring that companies are accurately calculating and disclosing their greenhouse gas emissions and looking at their climate risks, and thinking more about the role of the private sector in addressing climate change more generally, especially as government action has fallen short in a lot of ways. The transition that we're seeing from voluntary to mandatory has been driven in large part by the EU, where they had, as part of the Green New Deal, a lot of very ambitious new sustainability frameworks. And some of these frameworks, notably the Corporate Sustainability Reporting Directive, the EU CSRD, and the EU Corporate Sustainability Due Diligence Directive, the CSDDD, cover greenhouse gas emissions. And these are two really critical frameworks for multinational companies, multinational firms potentially. And so they have incentivized more actions by companies to measure their emissions and look at their risks. And then in the US, we have, or we had briefly, the SEC's climate disclosure rules at the federal level. Those rules are now paused indefinitely. The SEC has decided to cease defending those rules, which were challenged in the courts almost immediately after they were issued. But still, we have some US action on the mandatory side with the California climate disclosure laws, which are really, they will be filling to some extent the void left by the federal requirements. And I think that's evident from some of the state proposals that I will cover as part of the presentation. Looking more closely at some of these voluntary frameworks, you can see that there's actually a direct line between some of the influential voluntary initiatives and these mandatory frameworks. So first, the Greenhouse Gas Protocol is being referenced in virtually all of the new reporting frameworks. It's serving as the global standard effectively for reporting, and we see it referenced explicitly in the California climate disclosure laws. We also see the Task Force on Climate-Related Financial Disclosures, the TCFD framework, being referenced or incorporated. And so we see that in the California climate disclosure laws, and also in the national laws that are incorporating. You see here on the right-hand side, the International Financial Reporting Standards on Sustainability, and I'll talk more about those in a moment. So I think most on the call are probably very familiar with the Greenhouse Gas Protocol, but I'd like to spend just a couple of minutes talking a bit more about the TCFD, given that it informs the California framework and some of the other frameworks. So the Task Force on Climate-Related Financial Disclosures, the TCFD, it was established by the Financial Stability Board in 2015 to improve transparency around climate-related financial risks. And the goal was really to help investors and lenders and insurers make better decisions by accounting for climate-related risks and also opportunities. And in 2017, the TCFD issued a set of recommendations outlining 4 key areas for disclosure. So those are governance, So how companies oversee their climate-related risks and opportunities, role of the board and management strategy, the actual and potential impacts of risks and opportunities on the company, risk management, so how that strategy is operationalized, how companies are actually identifying and assessing their climate-related risks, and metrics and targets. And these are the measurements that companies use to assess their climate-related risks and performance. And those include disclosing scope 1, 2, and this slide notes that if appropriate, it's the newer versions are encouraged scope 3 greenhouse gas emissions. So that there is overlap between this framework and between two of the California frameworks that I'll talk about in a moment. So the TCFD was very successful, adopted globally, and it was formally disbanded in 2023 only because it's been fully incorporated into two new sustainability standards, which have been issued by the IFRS Foundation. So you can see on this slide here that we had, as showed in the previous slide, we had the TCFD. It's now incorporated and morphed into two new standards. So one IFRS S1 on general sustainability disclosures, and the other on climate-related risk disclosures specifically. So that's IFRS S2. These standards are aimed at creating a global baseline for sustainability reporting integrated into financial reporting. The idea is that they will move on to other topics from here, likely nature, biodiversity related reporting. And these are much more detailed reporting requirements as compared to the TCFD. So much more granular about how specifically companies should disclose their climate related risks and opportunities. And we're seeing now in jurisdictions around the world, these standards being incorporated into existing statutory requirements for financial reporting. They're also referenced in California's law, which I'll turn to finally in a moment, which shows how the California legislators anticipated the development and rollout of these standards, and we're trying to make it easier for companies to comply with their reporting requirements and also comply with requirements in other jurisdictions. So I think that the key takeaway here is that there's a common core to some of the new mandatory disclosure requirements oriented around those four pillars of the TCFD, the governance, strategy, risk management, and metrics and targets. So turning now to disclosure frameworks in the United States. The California climate disclosure laws are worth looking closely at for a couple of reasons. First, they're the only enacted requirements in the United States. And second, they're informing requirements that are proposed in other states, particularly in the absence of those federal climate disclosure rules. So these were passed in October 2023, and SB 253 and SB 261 mandate disclosures for all companies, US companies that are doing business in California that meet certain revenue thresholds. So it's more than 1 billion under SB 253 and more than 500 million under SB 261. And SB 253 requires annual disclosure of scope 1, 2, and 3 emissions in accordance with the GHG protocol. Those disclosures will begin in 2026. We don't have the precise date yet, but we should know more on that soon. And scope 3 after that in 2027. There is a requirement to have these disclosures independently verified by an independent assurance provider. And so that will start at a limited level of assurance in 2026 and phasing to reasonable level of assurance in 2030. And it's possible that the assurance might be required for scope 3 emissions in addition to scope 1 and 2. But that's also to be determined. For SB 261, which addresses climate-related financial risks, but as I pointed out, TCFD also, it incorporates the TCFD requirements, which also reference greenhouse gas emissions. So you would have, depending on how you interpret the requirements, greenhouse gas emissions disclosure obligations under both SB 253 and SB 261, if you were in scope of both laws. SB 261 requires preparing a biennial report on climate-related financial risk. That would be in accordance with the TCFD or ISSB standards. These reports will be very helpful for investors in theory. It will be difficult for companies that are subject to similar but slightly different requirements in other jurisdictions, which include the EU. The last California law I want to highlight is not specifically a greenhouse gas emissions disclosure requirement or climate-related financial risk disclosure requirement, but kind of touches on both elements in a way. Is AB 1305, which requires companies to make disclosures around net zero, carbon neutrality, and significant emission reduction claims, and also their purchase, use, and sale of carbon offsets. So if you're in scope of this particular law, which is already in force, you are required to publish certain information that explains essentially how the claims you're making are substantiated, and if you have targets and goals related claims, what progress is being made towards those, and also whether there's been independent third-party verification of the data. So AB 1305 is a very broad scope. You can be in scope even if you're not selling or purchasing or using carbon offsets on the basis of those significant emission reduction, carbon neutrality, net zero claims. So it's still something for law firms to be aware of, to the extent you might be making some of those claims publicly in California. So what's interesting about California laws, the extent to which we're now seeing, as so often happens with California, very similar legislation in other states. So right now we have proposed legislation in Colorado and New Jersey and New York and Illinois. There are a lot of similarities between these different proposed laws, some minor differences, but there is the potential for kind of more complex patchwork of GHG disclosure requirements across the United States. This would have been avoided to some extent by a federal rule, but we are where we are on that front. I think that the text here may be a little difficult to see, but the basic takeaway is that all of these laws share core components with California's SB 253. They all have a 1 billion threshold. They would all eventually require reporting scope 1, 2, and 3 emissions to the state regulator or an emissions reporting organization. They all require reporting in accordance with the GHG protocol. They all will require assurance to some extent. It's not shown here. They all would specify some administrative and civil penalties for non-compliance. So the specifics, kind of the way in which these laws vary, there's some variation in the timing and phase-in, obviously. There's some differences in how exactly the scope is defined in terms of what it means, the specific wording around operating within the state and doing business within the state. There's more detail in some of these cases, kind of learning from California's experience to kind of clarify some of the issues. So in some cases, there's language making clear that you could comply with the state law if you are also reporting in accordance with California. There are, I think, in a couple of cases, some variation in terms of what how the assurance process would work and those requirements. But in general, it's a pretty uniform approach. And interestingly, we don't see any similar proposed bills to California's SB 261. So all of these proposed laws are focused only on reporting scope 1, 2, and 3 emissions. They're not also requiring, and there's no sort of parallel legislation requiring reporting on climate-related financial risks. So none of these seem likely to be enacted in the immediate or near term. Not expecting these to move in this session, but a couple have been reintroduced before, and the direction of travel seems pretty clear. So some degree of mandatory greenhouse gas disclosure reporting seems likely, not just in California, but also outside of California, even if we can't determine exactly when that would begin. Something that state regulators and legislators are likely watching is there is ongoing litigation challenging the California laws. The challenge is on the basis of alleged violation of the First Amendment and compelling speech. That's ongoing. There will probably be some resolution by early next year, and that, to the extent that that law is upheld as drafted, that would obviously make it more likely that the California model will be followed. If there were changes from that would be taken into account. In addition to the ongoing litigation, there is also an increased risk of legal challenges to all of these laws, if and when they're enacted as a result of the Trump administration's recent executive order targeting federal overreach. The order directs the U.S. Attorney General to identify and stop all state laws, regulations, policies, and practices that might be unconstitutional or preempted by federal law. And it's focused on any state laws that address climate change or involve greenhouse gas. So clearly these types of state level greenhouse gas disclosure laws are squarely within the target of that executive order. So I think that there is a relatively clear trend, but definitely some headwinds. And at the moment, it's California that's the driving force for increased pressure on clients and companies, and potentially those requests to law firms that I mentioned earlier. Turning now to reporting frameworks, the international level. The main frameworks there are two really critical frameworks, both of which I should say at the outset are in flux. There's a process now going on in the EU to scale back and simplify these frameworks. So I can talk a bit more about that, but sort of take all of this, I guess, with that qualification. These are very relevant for U.S. multinationals that are operating in the EU and any of their business partners. So the EU Corporate Sustainability Reporting Directive, the CSRD, it's been the focal point of climate disclosure preparations for many companies for the past few years. It incorporates and builds on existing frameworks, including the TCFD, and it's designed to be interoperable with those IFRS sustainability standards. And there is a pushback at the moment because of just how broad and detailed the scope of the disclosures are. The pushback is kind of crystallized in this omnibus legislation that the European Commission is proposing that would revise and simplify to simplify the reporting requirements to really reduce the number of data points that companies need to provide. It could impact the climate-related disclosures and likely will to some extent, but climate is considered under the CSRD a kind of presumptively material topic for companies if they choose not to disclose it in their annual reports. They have to justify that. And so climate is less likely, I think, than some of the other sustainability topics that are covered by the CSRD, like biodiversity, to be significantly kind of scaled back in terms of the scope of the requirements. So as an example, again, this could well change, but this is an example of the climate-related disclosures that are actually required under CSRD. So the way the framework is structured is there are sort of these cross-cutting general disclosures, and then they're supplemented by topic-specific disclosures. And climate change is dealt with in the section's titled E1 of the ESRS, and those are the European Sustainability Reporting Standards, which lay out all of the specific requirements under the CSRD. So you can see here that those same topics that I highlighted from the TCFD framework are all included: governance, strategy, risk management, metrics and targets. We see the same requirement to report on scope 1 and 2, but here it would be mandatory reporting on scope 3 emissions. There is, I think, to some extent, a lot of companies would be okay to report on this, but there is a requirement to report on transition plans for climate change mitigation, which can be sensitive for a lot of companies, and that's an area where I think we might see some changes through the omnibus process. The second reporting or due diligence framework that has a reporting component that relates to GHG disclosures is the EU Corporate Sustainability Due Diligence Directive, the CSDDD. And this framework is intended to harmonize due diligence requirements across the EU. Again, as a result of this omnibus legislation process that's ongoing, the scope is likely to be curtailed, and I think the requirements will be reduced, but at the moment, there is this requirement to adopt a climate transition plan. So this is and somewhat of a kind of odd addition in a regulation that's really focused on supply chain due diligence, but it is there, and it would require companies to actually adopt a climate transition plan and to put it into effect. There wouldn't be a requirement to actually achieve the targets set in the plan, but the plan would need to be adopted. You can see the main components here, but actually setting those emissions targets and describing how the company will reach those targets and what investments they're making to actually reach those targets, how the plan is being supervised and managed, and it would need to be updated annually. So the omnibus proposal would amend this part of the CSDDD to just soften the requirement a bit, so that rather than putting the plan into effect, they would just need to adopt the plan with implementing actions that would seek to kind of realize the plan through best effort. So just a change to kind of reduce the weaken the obligation, which a number of NGOs are not happy about, but it's definitely on the table. So there are also requirements to scrap the CSDDD entirely. So we'll see how those play out. But even if this were to be removed, there would be that requirement to report on climate transition plans under the CSRD that I mentioned earlier. So the those are mandatory reporting frameworks if you're in scope through your operations in the EU, the CSRD and the CSDDD. So separate from those, as I mentioned, we're seeing countries around the world incorporate the International Sustainability Standards Board's IFRS S1 and S2 standards, which include GHG disclosure requirements. And we're seeing already, you can see some of the countries listed here: Australia, Canada, Japan, Singapore, others moving ahead with this. As of the end of last year, there were 13 jurisdictions that had adopted the standards on a voluntary or mandatory basis, and 22 other just jurisdictions that had announced plans to adopt them in the future. And these requirements are, as I mentioned, the CSRD requirements are designed to be interoperable with these requirements. And so there's that same kind of granular level of disclosure around climate-related risks and risk management, strategy, transition planning, and greenhouse gas metrics. And these requirements also refer to industry-specific requirements as well, which are still in the process of being revised and finalized. I think as I mentioned at the outset, there's another kind of piece of this for law firms, in addition to potentially being directly in scope of some of these disclosure requirements and potentially getting requests from clients in relation to these requirements. There's also, well, what are law firms saying publicly about their own GHG disclosures, perhaps motivated by those client requests. And there's definitely some challenges and risks in the current environment around these types of claims. Some of you may work in this area, but we're seeing a lot more litigation targeting sustainability related claims from consumers and environmental NGOs, investigations, particularly in the EU. And it's an opportunity, I think, or an opportune time for companies to revisit claims that they may have made recently that are up on your website or otherwise part of their marketing materials relating to the firm's kind of sustainability credentials, and definitely any kind of carbon footprint related claims or net zero carbon neutrality type claims, because we are seeing new regulatory frameworks addressing those claims. Not in the US. In the US, as you can see here, we have the Federal Trade Commission's green guides, which are non-binding enforcement guidelines relating to green claims. We were anticipating that those would be refreshed. That process started under the Biden administration, and but now it's almost certainly not going to move forward. The green guides are still relevant, and I think to the extent you taking kind of a second look at any public claims that you're making related to climate or sustainability, they still provide important principles that are relevant, generally making sure that claims are substantiated, making sure that if you're relying on third-party certifications or standards, that you're doing that in a thoughtful way, and making sure that those standards are credible, and what you're communicating in relation to the standards is substantiated. But outside of the US, we are seeing new frameworks. So in the EU, two new recent frameworks. There's the Empowering Consumers Directive, which is already in force, although enforcement at the member state level hasn't begun yet. And the Green Claims Directive, which is being finalized and expected to be finalized this year. And both of these will apply to non-EU companies that are engaging in covered practices in the EU, so marketing directed at EU consumers. And the Empowering Consumers Directive has new restrictions on environmental claims, including environmental characteristics and also social characteristics. And some of the types of claims that are prohibited include generic claims and carbon neutrality claims that are based on the use of offsets. So you are permitted potentially to make claims relating to offsets that are within the life cycle of a product, but not outside of it. So again, how relevant this would necessarily be for firms, it depends on exactly what types of claims you may be making in the EU. And for the Green Claims Directive, this will be a more significant change in how these types of claims are made and regulated, because there would be a requirement for evaluating whether these claims are substantiated before the claims are made. There's likely going to be some changes to simplify that process, but that's the basic concept. And here again, there would be that prohibition on carbon neutrality claims based on offsets, but there would be an ability to make claims that there would be an ability to make claims relating to at the company level relating to offsets, so long as certain requirements are met, including having a net zero target and being on track to meet that target. So what these requirements and similar requirements that we're seeing in a couple of other jurisdictions reflect is there just is so much more that companies are saying about their climate related goals and the steps they're taking to meet those goals. And it hasn't been kind of an equivalent development in the regulatory frameworks to make sure that those statements are accurate and not misleading. So I think there is that intersection, as I mentioned, between the pressure that we're seeing for more disclosure and the increasing regulation of what actually gets disclosed. So just to wrap up, I think touched on most of these, but at this point, even though some of these frameworks, kind of their status is uncertain, I think it is useful to be preparing for increased climate related requests from clients and business partners. Even if some of these mandatory requirements don't materialize, voluntary standards are still in place. There's still a lot of pressure for companies to be transparent about their scope 3 emissions. And so I think it's still fair to anticipate an increase in requests and also expectations that law firms will be taking steps to increase the ambition of their sustainability activities. As in relation to that, I think it's a good time, as I said, to think about sustainability related claims, but also the tools that you might be using to collect your emissions data and report that data. There's been a really dramatic increase in the number of vendors and platforms that are out there offering emissions calculation and reporting services to companies. Some of these platforms, I think, can offer a lot of benefits and efficiencies. In other cases, it's not clear that they're the right fit. So it requires some kind of careful evaluation and comparing the different offerings that vendors have. I've already touched on the claims point, and then just monitoring these frameworks. I think that's helpful in terms of getting ready for those potential climate related requests from clients, and also managing that green marketing risk, to just keep an eye on how these frameworks are developing. So I'll pause there and see if anyone has any questions. I think it's a relatively small group, so happy to have kind of more of a discussion if folks are interested.
Hi, Claire, this is Craig Gannett with Dave's Right. That was absolutely excellent. Thank you very much.
Great. I'm glad you enjoyed it.
Yeah, and this isn't necessarily your area either, but I'm trying to get my head around this First Amendment argument that's been made in the California legislation. That just seems, it's counter to my intuition, at least. And but I haven't delved into it. Do you have any sense of what that argument looks like and likelihood of success?
So I'm certainly not a First Amendment expert. I mean, I think they're focused on the idea that the speech that's being compelled, is potentially like harmful and damaging to these companies to have to publicly disclose their climate related financial risks and emissions. It seems relatively weak to me. I mean, the court dismissed their other constitutional claims that said that it needed more factual information for the First Amendment claim to kind of figure out what level of scrutiny would actually even apply here. So I sort of read that thinking they're not willing to throw it out at the outset, but there seemed to be some skepticism there. So I would not rate the prospects of success particularly highly for that one, although I think it's a creative argument.
Yeah, I wouldn't either. Lots of companies have tried this in the past in relation to sort of environmental reporting, and it hasn't worked. So I don't have case law in front of me, but it seems like an uphill fight. And if it does work, it also means that a whole lot of other environmental reporting on a that's not related to a permit or other kind of authorization could kind of be in peril. So I'm skeptical. I don't think it's impossible that they win on it, but I'm skeptical of it.
Great, thanks. That's helpful. Yeah, it does seem like it's hard to imagine that the First Amendment would cover this, but not a whole ton of other stuff that heretofore had never been questioned in terms of the ability to require its disclosure. So anyway, it'll be interesting to see how the judge deals with that once he has a more complete record.
Yeah, we'll see. Claire, I have one question on the sort of one of the topics you were touching on towards the end there. So the Green Claims Directive, how do you think law firms might need to be paying attention to that a little bit, particularly those that are doing business in Europe?
So I think that the basic focus of that regulation, it seems more product focused, but it actually includes services as well. So if you are marketing your legal services in the EU and you're making claims potentially about the carbon neutrality of your firm, or maybe you as a firm you have a net zero goal, making sure that you are aware of what the specific requirements are going to be in terms of the information you have to provide alongside those types of statements. So I think at this point it's definitely unclear to what degree there will be carve outs or kind of simplified procedures to comply, which I think speaks to the monitoring point, but it could be relevant just to the extent that you're really making any kind of marketing claims that touch on your climate goals and progress.
Yeah, okay, that makes sense. Skylar has put some in the chat that reads, "Thank you for the informative presentation. Are there any resources, recommendations to help firms evaluate GHG emissions vendors?" So, Skylar, at LSN, we have our own GHG calculator, but I understand that the calculator is one thing and actually collecting all the data and using all the data is another, which we're dealing with at our firm. We are in the middle of onboarding a member that is in the consulting space that actually does this. We have a membership category for service providers in the sustainability field. So I suspect we'll have more information about that this summer. And in addition, we are working to build out some more member resources on options in that space. It can be a little challenging, and it can be a little challenging to right size it. There are big companies that do it, but they charge a lot of money. There are small companies that do it, but then tracking them down can be a little tricky depending on where you're located. So I hear you. So not a perfect answer, but maybe somewhat helpful. Do others have questions? No? Well, Claire, that was great. Anything else you want to close with before we wrap up?
No, I think just, as I mentioned, some of these are moving quickly, at least on the EU front. So if that's relevant for your firm, I'd definitely keep an eye on the EU omnibus legislation I mentioned.
Yeah, I'll also be interested to see what those other 4 states do.
Yeah.
It's interesting that Washington State, which has, as complete a set of climate laws as just about any state in the country, they just finished their legislative session this year, and there wasn't a peep about this. So I think, Claire, as to your point, they're probably in the camp of waiting to see how the California litigation, unfolds before going ahead. But I can imagine that Washington would join those other 4 states, next year if the litigation looks like it's going to, turn out okay.
Yeah, I think so. I mean, they did have a bill that then I think it was modified so that it would just kind of set the process in motion for potentially proposing similar requirements to the California law. But as you said, I'm not aware of any movement on that. So I'd say kind of a step behind the other states I mentioned, but is, I think, already shown, what it would do if the time was right, and it would look very similar to what California has proposed currently.
So that was that was Washington legislation?
Right.
Oh, okay, great. I completely missed that. I was watching toward later in the session, and I didn't see.
No, it was,
Yeah.
I didn't include it because they don't have, there is no bill proposed at the moment to actually mandate emissions disclosures. There was initially a bill that was then, I think, amended to just require the regulator to assess the possibility of proposing these requirements.
A study bill, sort of.
And that was I think it was last year.
But it was not enacted.
No.
Interesting. Thanks. I missed that. Well, thank you very much, and please give my best to Eric Christensen, an old friend.
We will.
Oh yeah, Craig, if he's an old friend, he won't mind telling you that he's recovering from knee replacement surgery this week and is looking forward to the upcoming ski season. So
Oh, good. Well, tell him to take it easy. Don't rush his recovery.
I will. I'm covering some stuff for him. He and I are friends, and we do a lot of work together.
Yeah, he's a great guy, old friend.
Yeah, for sure. Great. Well, thanks, Claire. I think we can wrap up a couple minutes early, let people take a break before their next meeting, and hope to see some of you in a future LSN webinar or member forum. Thanks.